Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, welcome folks to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman, and this afternoon we have with us, or it's your morning, I suppose, Jordan Couch from Palace Law in the state of Washington. Nice to have you, Jordan.
Thanks for having me.
Absolutely. First question for all our guests here, Latte with a Lawyer, what's your morning beverage of choice?
So I'm going to get myself thrown out of the city of Seattle, but I actually don't drink coffee. I'm a big fan of tea, though. And so in preparation for this podcast, I actually walked over to the local coffee shop and they have a really good Earl Grey tea that I love. And so that's my go-to in the mornings. It's like an Earl Grey tea, or if I want the latte side, like a London Fog, you know.
Got it. So no coffee in Seattle. Wow. You're right.
Yeah.
You might be in trouble.
Yeah. This is how I get canceled.
Yeah, I'm sure you're gonna be fine. Okay. So anyway, so tell us what your law practice is all about. What kind of law you do?
Yeah. So our firm, Palace Law, our mission is to ensure justice for the injured in every community. So we do personal injury and workers' compensation in Washington, and we actually just expanded into Oregon. I got my license a couple weeks ago. And so I focus on the workers' compensation side. I manage our workers' compensation team.
Okay. So talk about that. Tell me, what does that mean? What's the day-to-day of being a workers' comp attorney?
Yeah, so it's a kind of a balance, I'd say, of three things in my job. One is just managing the entire team, which is, your basic managing people in a firm. On the actual workers' compensation side, though, there are two levels. There's the administrative level, where I'm handling cases that are still at the Department of Labor and Industries or at the insurance level with, state fund companies, trying to ensure our clients get benefits. And then the last portion of it, my favorite portion, is the litigation side of things. It's kind of like, filing a demand in personal injury versus actually going to litigation in personal injury. Ours is at the administrative level. We manage these cases and work these cases. And then if things go wrong, we get into litigation. And so I have a litigation caseload as well that I'm working on a daily basis. So day to day, it's a high volume industry. I'll talk to a bunch of my clients, make sure they're on track to get the benefits they're entitled to, talk to some of their doctors to make sure we're getting the paperwork we need, and then work on prepping my litigation files, which is a lot like any other litigation, except I do a lot more of it than most personal injury firms I know.
Okay. So a couple of questions I was going to ask you. First of all, how big is your team? You said you manage the team. How big is your workers' comp team?
My team is 9 people, and that's 3 attorneys, myself included, and then I have 6 paralegals to work on that. And then we also have some, administrative people that are kind of under me that work on the litigation side as well, helping out with that stuff and kind of doing administrative stuff for us.
Okay, so you have a busy practice, it sounds like.
Yeah, the practice in total is over 30 people, and we kind of have it set up into 3 teams, and then our management team oversees all of it, which is the personal injury team, the workers' compensation team, and then the administrative office support team.
Okay. So in a workers' comp case where you're trying to secure compensation, I assume, for the employee, how do you work? Are those on contingency? Are they billable hours? How do those work?
In the state of Washington, everything is on a contingency basis. I'd say 90% of the time. There are some exceptions where if cases get up to like the Court of Appeals, the Supreme Court, we can start billing on an hourly rate if we win. So it's still a contingency fee, but it's a little bit different in that context. But most of our work, 99% of it is all contingency fee work.
Okay,
we help clients get benefits. We get a percentage of that.
Okay. So so it's very clear for everybody, just describe like what a case would look like, or if there's one that stands out that you can talk about.
Yeah, I can, those are two sides, right? There's the everyday case and the standout cases. The everyday case, I'd say, is someone is lifting something at work, they hurt their shoulder or they hurt their low back. 6 months later, it turns out it wasn't just a strain. There's something more going on there. The employer is trying to limit their benefits, say, no, they don't get the surgery they need for that herniated disc. That's unrelated. It's just age degeneration. Yep. We get into litigation about that, hiring doctors to testify, at the administrative level, which is kind of like a bench trial, basically. And so we're fighting to say, no, this surgery needs to be authorized so they can get the care they need. And then after that, follows their benefits, their impairments, their all that kind of stuff we get money for them on. So that's your bread and butter everyday case.
Okay.
I'm a little bit known for liking the unique cases. There are people on my team who will talk to me and say, "Hey, Jordan, I had this weird case that I feel like we probably shouldn't take, but I wanted to check with you first because it's weird and I know you like those." So I've had a lot of bizarre cases. I've had a client who had a condition that there were only 500 documented cases of in history, which was funny because the employer's the doctor they'd hired had to admit, yeah, actually the doctor that saw your patient and is, treating you and testifying for you was my professor in school. He taught me everything I know about this stuff because there were so few people that actually knew about this. Erdheim-Chester's disease was the name of the disease, right? Just extremely rare stuff that comes up.
Which is what?
For weird work situations.
Which is what? What is that?
It is, it was, gosh, I got to remember all the details now. It was kind of a deterioration of the bones with little holes in it, if I'm remembering correctly, that was aggravated by an injury he had that was kind of a sudden blunt trauma to his back. And so, yeah, it was an interesting one to kind of have to deal with the ins and outs of like what should be covered by the employer if this was clearly a pre-existing thing versus not.
Got it.
Yeah.
How big are these
Sadly,
awards?
we settled. We didn't.
Yeah, I mean, how big are these awards that you typically get for the employee, I should say?
Yeah, so workers' compensation is kind of a safety net system. So you always have to caveat that with, there's no pain and suffering compensation, things like that.
Okay.
It's really broad. And what's interesting about it as well, at least in Washington, is there's not necessarily one payment, right? In personal injury, you get everything done at the end, you get one check and that's it.
Right.
In workers' compensation, I've had cases where I get a check for a client that we get benefits for them and we take a fee off it 10, 15 times. That's rare, but it happens because you might have a circumstance where, one of their benefits is they're getting wage replacement benefits every 2 weeks while they're injured, right? And it might get stopped because they get a bad doctor to say he's able to go back to work. And then I got to fight for 6 months of back pay and I do that and I get one accounting. And then later on, they're eligible to be retrained, to be sent back to school as another benefit. And they decide, I don't really want to do that. I'd rather just take a settlement. So they get another settlement out of it, right? And then at the end of it, they've got all their treatment, they're back to work, they're living their life, and they've got some permanent impairments, and we get an award based on that. And then last but not least, the bigger cases are the cases where they're unable to return to any work ever again. So they get paid out a pension for the rest of their life. They get paid every month. Those are the big cases. Those are the cases that break $1 million in value pretty regularly, right? But those are less common. Most of our cases, is really we're getting that permanent impairment award for them. And that, when I talk about a safety net system, in the state of Washington right now, this is how bad it is. 100% impairment, and everything's based on percentages of full body impairment, right? 100% impairment of the full body, I think last I checked was $223,000. So it really is a safety net system, right? And so if someone has 10% impairment of their right shoulder, that's only going to be worth about $11,000, right? Because it's all based on that whole body impairment.
Got it. Oh, I see. So everything is sort of spelled out and capped and.
Yeah, it's the fighting about money is less important than fighting about the damage and the medical side of things. We're really intent on you have to fight about the medical, make the stories, that kind of stuff.
I see. Okay, got it. Do you have situations where the employer is not fully insured, or is that not a thing?
I've had a couple of cases like that. That gets into some interesting legal issues. Every employer in Washington is required to be insured. If they're not, they're covered by the state of Washington. The interesting case I had on that had to go up into the appellate process was because we had an employer that didn't have a lot of employees in Washington. I think my client might have been the only employee in Washington. And so they were what's considered a self-insured company where they cover themselves and they're required to have full coverage, but only in, I think, Minnesota or Michigan, whichever, I can't remember which state they were located in. They had no coverage in Washington at all. So Washington said, well, then we take over. And so Washington automatically takes over the coverage. But then it got into this fight with the employer where my client was kind of a pawn in this giant tax audit between this big national employer and the Department of Labor and Industries. And he's just this one employee that we had to kind of get stuck in the middle of this process.
Yeah. Well, I would think, the state doesn't want to have to take it over. That's a cost that they don't want to have to, right? Take on.
And Washington's lucky in that respect. Some states are getting worse and worse in the benefits they offer and the coverage that's available. Florida, a few years ago, even had a judge rule that the entire workers' compensation system was unconstitutional because it was so imbalanced against injured workers, right? So Washington has its problems in its system, but one thing is there's a strong bias towards coverage, right? If you're a Washington worker, you're covered. One way or another, they make sure that you're fully covered.
Yeah, that's great. Well, it's a more liberal state, isn't it?
Yeah. definitely than Florida.
I'm in the state of Florida, so I can tell you that it is definitely more than Florida.
Yeah.
For sure.
Yeah.
Yeah. We're making the news almost every day now. So there you go.
Yeah. Always fun when you're in the news.
And we'll leave it at that. So how did you get into this line of work? Take us along that journey.
It was kind of a funny stumbling path. And I went to law school knowing I wanted to be a trial attorney. I, in law school, found contracts really interesting because I liked that kind of nitty gritty, weird disputes of, you can write whatever you want. But as I progressed, I realized that contract lawyers don't go to court ever, right? Because it's always about money. There's always a settlement value. It's not ever, but pretty much never they go to court. And so I was looking more on the personal injury side because I like the idea of helping people and getting involved and really helping people. And I'm a huge science nerd, right? I spent one summer in law school working for NASA because I love that kind of stuff. And so finding in personal injury that I could blend the medical knowledge with other things was really fascinating to me. I didn't know workers' compensation really existed. It's not talked about in law school, at least not mine. But I came out to Washington after graduating law school and moved to Seattle and didn't know anybody except my then girlfriend, now wife.
Got it.
And didn't have any connections in the legal industry. And so I just started kind of going around trying to find things to do. And it was a funny coincidence of things coming together in that on the one hand, I kept meeting these people who would say, you have really similar interests to this guy who was our former bar president, Patrick something, right? And I think, great, I'm gonna have to look this guy up and like check him out later on and see, he and I have similar interests in innovation in law and how to bring better justice to people. And at the same time, a friend of mine was from college, was working as a receptionist in a workers' compensation firm in Seattle. And one of her paralegals heard I was looking for a job and sent an email to me saying, hey, this other firm that does workers' compensation is looking for someone to do some contract work on a court of appeals case. You should reach out to them. So I got a job with them doing contract work at this workers' compensation firm and started learning it and realized like, this is kind of interesting and I enjoy this side of things.
Okay.
And then I was at this event in Seattle about legal innovation and they're introducing people and the guy introducing everyone says, and we're so happy to have our former bar president, Patrick Palace, here with us tonight. And he points to the guy sitting in front of me.
That's you.
I was like, that's convenient. So as soon as it's over, I introduced myself and I said hi. And it turns out Patrick Palace of Palace Law was a workers' compensation attorney. And he said, I got to be very clear with you. I'm not hiring anyone. And I said, that's fine. And he says, but I just want to hear about your interests. I hear we have similar interests. I have a job right now. Like, I just want to learn about your firm and what you're doing. And he said, great, reach out to me. We'll get coffee. So I emailed him like a week later and said, hey, when's a good time to get coffee? And his response to me was, send your resume to my assistant. And all I could think was like, what in the hell? Like, who is making me send a resume to get coffee with this guy? Like, is he just that much of a jerk? So I sent my resume anyway. And she said, hey, when do you want to come in for your interview? And I went, wait, I thought he made it very clear to me he was not hiring and now I'm being interviewed. But hey, 7 years later, I'm a partner. I'm still there and I'm not leaving anytime soon. So
Oh, that's great. Great story.
yeah.
Why'd you
And I
become?
love workers' comp.
Okay,
I
yeah.
was just saying, we
Sorry, go
litigate
ahead.
all the time. Like that's one thing I found about workers' compensation is it gives me the ability to help people, to choose my clients, to work with real people in their, hopefully what's the worst situation of their life. And I get to go to trial all the time. Like we try cases a lot, which is really fun because you've got this kind of weird system where you can litigate specific issues and it just leads to a lot more trial work.
Yeah. And these are bench trials, I assume, right?
Yeah, it's a funny system in Washington, at least, where you start out with basically a bench trial, right? It's an administrative judge, but all the civil rules apply, all the rules of evidence apply. You present your case to this board judge. If you lose, you can actually appeal to Superior Court and have a full jury trial
Oh,
on a closed record. So you're reading the transcripts to the jury. Like we'll have people come in and sit and act as readers to pretend to be the witnesses, and it's an interesting system where you do get bench trials and then it goes to a jury trial.
oh, interesting. So how many jury trials? I mean, how many? How often does it go to a jury trial? I guess is my question.
Not very often. I think one element of having that bench trial beforehand is, mediations help increase settlements because there's conversations beforehand. Having an
Yeah.
entire trial before the trial also increases settlements because once one side loses, they get a better perspective on what the value of their case is. And so most cases that don't settle before litigation still settle. I'd say over 50% settle between that board decision and the Superior Court case. But I've still had a few jury trials in my time in this, and we have a couple coming up right now as well. And we just finished one in the office, so
Yeah.
it happens.
Is the value that you get on these cases, is there any subjectivity or is it just pure math?
it's a balance, right? Once we have the impairment rating, that is pure math, right? The impairment rating is 10%, that equals this dollar amount.
Yep.
But there's a lot of subjectivity, and I wouldn't necessarily say subjectivity so much as medical dispute that can be, played around with between that 10%, because one doctor might look at a patient and say, hey, your back is at category 1, which means no impairment. Another doctor may look at them and say, no, that's category 3. Or one doctor might say, yeah, you have an impairment in your shoulder, but that's not related to your claim. And the other doctor says it is. And so there's that same subjectivity of telling the story to connect the dots on causation. And I think our biggest fights in the workers' comp system are really about causation. And then there's also some balance where you get into, how a doctor does an impairment rating. It's based on things like range of motion, and two doctors might do it different ways on different days, or people have good and bad days. And so you get into those disputes of subjectivity as well about, what a person's impairment really is. But once you have that impairment number, then it's just math.
Yeah, but getting to that impairment number, there's some back and forth. So who's the arbiter of that? Like, how do you get that reconciled when you have differences of opinion?
It'll be the judge, right? So the first one at the administrator level is, the Department of Labor and Industries. But that's kind of like an insurance company. You're sending a demand to. If they don't agree to it, you don't take it personally. You just move on to your case, right? Like, you hope they do the right thing. If they don't,
yeah, right,
get over it. But really, then it becomes the judge as the fact finder, and then ultimately the jury gets to decide. Like, you get to present the evidence to the jury and say, these are, this doctor says category 1 for a low back impairment. This doctor says category 3. It's up to you to decide who's right. And here's the evidence we're presenting to you as to why this doctor is right.
Okay, good. Excellent. So you ever focus group those things just to see what an independent group would think?
We have a few times. One problem you have in the workers' compensation, because it's high volume, low value, is focus groups are expensive. And so doing this, spending a bunch of money on a focus group might take away all your clients' money that they win in the case, right? And you don't want to do that. So you're always mindful of that. But we do some smaller focus groups, and I've started working with some friends of mine who do that, about sending out kind of questionnaires on discrete issues and say, like, hey, here's my story of how this injury caused this condition. Do you buy it? Why not? That kind of stuff.
Sure. Okay, got it. Excellent. So let me, I know you always want to be a trial lawyer, but why'd you even become, like, when did you make the decision that you wanted to be a lawyer? When did that happen? Was there any influence along the way?
Yeah, silly decision. When I want to say like 12 years old, I saw like a newspaper clipping that my parents had, an old scrapbook of my father from debate, like wearing a suit from high school debate. And somehow in my mind that equated with being a lawyer, and I decided I wanted to be a lawyer. To be clear, my dad was not a lawyer. My dad didn't graduate college. He became a fishing guide, right? Like kind of the opposite end of the spectrum.
Yeah.
But in my head, those things were equated. I started doing high school debate, which doesn't have a whole lot of bearing on the practice of law. But as I was doing it, I just kind of decided I wanted to do this. And I started talking to a lot of lawyers, like anyone I knew that I was a lawyer that I could ask questions of. I'd say, like, hey, why should I not be a lawyer? What are the reasons to not want to do this? And I was happy that most of the answers that were given to me were things that made me interested. They'd say, like, well, you're not in the court that much. It's a lot of research and reading and writing. And I'm like, this all sounds good, right? And I just kept on that path. And every step of the way, it just kept getting reinforced to me, like, this was a good idea.
Yeah, that's very funny. All right, so you're into it. So you're from Montana, is that right?
Yeah, Montana originally.
Wow, so that's a big, so, and your dad was a fisherman or guide. Okay. And I'm just looking at your background. That's a big change. So you moved yourself to Washington. Okay. Interesting. Anyone else?
Maryland first for college.
I'm sorry?
I said, yeah, Maryland first for college, Indiana for law school, and then out to Seattle.
Oh, wow.
And
you went to Maryland.
Here.
You went to College Park, Maryland?
No, I went to St. John's College in Annapolis, like right across the street from the Naval Academy. Yeah.
So you are an intellectual. I know that school. I lived in Annapolis, and I lived in Bethesda, Maryland for many years. That has quite a reputation. Now I know people have attended that. Okay. That now I understand your thinking. Okay. How big is
great
the
books program?
Oh yeah. What's the enrollment of that school? It's very tiny, right?
Yeah, ours was the largest graduating class in over 300 years, and it was 120 students.
There you go. So it's you have a really selective esoteric group of students, right?
Yeah, it's all the great books program, right? We read the the history of Western thought, basically, and study mathematics and science and music and literature all through that lens. So like in our science classes, we were reading Einstein's work or Harvey's work on the heart, right? Like that was the source material, which it's a fascinating way to go. It was a really, honestly, a good way to get in as a trial lawyer as well, because, and a lawyer generally, just building up these liberal arts skills where you can put yourself into any situation and learn it, right? Like, you know, in my work now, I have to learn medical stuff all the time. And
Right.
there are the attorneys that will always say, like, never go up against a doctor on the medicine, to which I tell the people I'm training, always go up against the doctor on the medicine, because that's how you beat them. But you better know the medicine better than they do.
Right.
Maybe not all of medicine, but you better know the medicine of this case better than they do, and then you go up against them.
Yeah. That's a tall order, to know the medicine better than the doctor you're going up against.
Yeah. You know, you got to, the more time you spend on a case, the more likely you are to win. And you just got to, I think it's most of the time, whoever wins the case is the person who puts the most work into it.
Right. Okay. So that's where you think of the traits you need to be good and successful? Just hard work, persistence?
Hard work, and you know, there's the right work too, right? Like you have to understand and be and have the rational mind to think about what matters, what doesn't, to cut through the flack of it. I think on the plaintiff side, especially, on, you know, the friends of mine who do defense, you know, their strategy is different, where they're putting up a lot of things, because if they can make it confusing and complicated, they win. On the plaintiff side, you have to have a clear story, and you have to be able to cut through everything else. So when they're talking about, well, he had an injury 20 years ago, you can say, who cares? That's not the point. What the point is, what happened now. That's what we're talking about today. And so being able to cut through everything. There's a great line in A Tale of Two Cities where Dickens describes a great lawyer as always having his arguments at the tips of his fingers. And I think about that all the time. Like, if you can't answer the sentence, I should win because, in one sentence, you're going to lose. You got to have those arguments at the tips of your fingers, and it's got to be focused and narrow and easy to go back to.
Got it. Very good. Excellent. Interesting. So you think you'll always stay on the plaintiff side? That's where you're meant to be?
I think so. You know, I have friends on the other side, and it's a lot easier for me to be working with individuals, with people, than it does, I think, to work for companies. I think my heart's in it more. I think it's easier for me to work harder when I know the people I'm working for and I care about them. You know, I think, yeah, I don't think I could have that same attachment to companies, to saving their bottom line, to helping ensure their profit margins, doesn't mean as much to me
Right.
as this person is currently suffering. They're in pain right now. I know them. I understand what they're going through. That's easy for me to, I couldn't work that hard, I think, on the defense side. I think I'd have trouble caring that much.
Got it. Yeah, I understand. It really does come down to passion.
It's good for people to do, though.
A lot of people do. You're right. Well, you also have to, I think you probably have to work a lot harder, and particularly around a case on the plaintiff side than on the defense side too. Is that correct? It's
Yeah,
less
I think so.
predictable. Less predictable is what I was trying to say.
Yeah, you know, it's funny on the business side, right? The more I've learned about the business side of plaintiff's practice, is it's so different, because, yeah, you don't get to bill hour, you don't get to have staff, you don't get to tell staff, like, hey, bill this many hours and you're going to make money for the firm. It's a different world where you live and die by your clients, which also I appreciate. You know, it's nice to have my goals are aligned with my clients 100% of the time, right? Like, I want the same thing they want. And that, I think, also makes it easier for me personally to kind of swim with the stream and be on the business side of things. I might have some socialist tendencies in me sometimes. And so being in a business where I can say my client's success is my success makes it easy.
Good. Excellent. So since you're a scholar, I'm going to ask you, what books are you a fan of that have been helpful to you, or what would you recommend somebody read that would be useful?
Ooh, all right. So on the litigation side, anything Rick Friedman has touched is worth reading. Especially on the plaintiff side, like, he just does a lot of really good books on trial work, and he even has like kind of an introductory one that I will go back to sometimes before a jury trial to remind myself, just kind of refreshing, like testing basics. I think is always a good one. So anything by Rick Friedman. On the litigation side, Nick Rowley has a couple books as well that I really like. You know, I think I have to translate them a little bit, because he's got his own method that works really well for him, but he's a unique personality, and so you can't just do what he does and make it sound good. I've tried it a couple of times. It doesn't work for me. It's not who I am. But I can translate what he says, and I love his human-centered approach to law, which I think needs to be done better. On the business side of law, two books that I go back to and actually give away to, like, interns all the time is Jack Newton's Client-Centered Lawyer. That is the future of the practice. That is, or the client-centered law firm. That book will tell you everything you need to know about the future of the profession right now as it stands. And if you're, for someone who's trying to get into law, especially like a law student who doesn't necessarily know where they are yet, Lawyer Forward by Mike Whalen is really good. It's, part memoir. There's a joke that, that one of his Google reviews was the book could have been an article, like a blog post, which is true, right? He did it as a blog post first, but the book includes more memoir to it, which I think is really nice for law students who might not know where their fit is in this profession to kind of figure that out and also understand the business side of the profession and where we're headed and how to improve things for the better, because that's something I care a lot about. Yeah, those are ones I'd go back to. And then the last one, I actually like taught a guest class at a law school about this. There's a great article from the Harvard Business Review a few years ago called "Are You Solving the Right Problems?" And it's about how to reframe problems. And I think this is something really missing in law, where for so many decades now, we've had lawyers come out and say, this is my client's problem. I'm going to apply the solution that my dad applied when he was a lawyer. And that's the progress of this profession. It's just the same things. And the more innovative lawyers started doing things like, well, let me explore different possible solutions to this problem and then apply one of those. But if you look at the system of justice right now, right, it's not working in a lot of ways, right? And Washington had a civil legal needs study that showed that low-income households had more than 9 legal problems in a given year. Solving each of those problems doesn't solve what's going on there. And so the idea of reframing problems is taking a step back and asking yourself, instead of trying to brainstorm how to solve this problem, why don't I look at what the problem is and see if I can define that in different ways? What are other ways I can approach the problem to see if I can solve that in a better way, in a more comprehensive way? And I think it has a lot of applications in law. The classic example of reframing is if you have a really slow elevator in a building and the tenants are all complaining, how do you fix that problem? Well, you can install another elevator, incredibly expensive. You can improve the engine in it, incredibly expensive. You can add an AI to try to make the elevator go better, to have different routes better. That's really expensive. Or if you talk to landlords about what they do, they put a mirror up next to the elevator. Because another way of talking about the problem, instead of saying the problem is the elevator is too slow, you could also say, well, the problem is people are bored while waiting for the elevator. How do you solve that problem? Put up a mirror, suddenly people are looking at themselves, they're checking themselves out, they don't even notice the time anymore. And that's actually how it happens, right? And so in law, I think all too often we can get trapped in, this is what I do as a lawyer, and not looking at our clients' problems and asking, okay, but how do I get them to, the problem is not just this legal issue they have right now, the problem is what got them into this situation. How can I approach this from a different angle? And I think you get a lot better customer service when you get outside of just, I'm a contractor with a hammer, everything looks like a nail when all you have is a hammer. We need to add to our toolkit so that our clients' problems aren't all nails.
It's, that's really excellent what you just said, because that concept is a challenge for every business, right? Really defining the problem correctly. And you're right. I agree with you completely. In fact, in a sales situation, people are typically treating symptoms as opposed to getting to the underlying problem. So you're right. That's excellent. I agree with you. Very good.
And it's sometimes even hard for our clients to understand. And I think lawyers being able to reframe these things helps as well, because I have clients who are tied to, like, I need to have my day in court. And if I can say to them, like, hey, you can have your day in court and it's going to take you months or a year and you're going to suffer through it and it's going to give you a chance. Or, what do you want? Like, what I always talk to clients about to try to help them reframe their problems, instead of them saying, what do you want your day in court? I say, when your case is closed. Forget about how we get there. Just don't talk about your day in court. When your case is closed, what do you want your life to look like?
Right.
Because that's the goal we're working towards. That allows me to reframe the problem and see, okay, how do I get them to that life, instead of, okay, how do I win their case? It's how do I get them to the life they want, rather than get them the specific tactics along the way they want. And that helps our clients reframe that idea for themselves a lot, because clients also get trapped in that. Like, I hired a lawyer, I want my justice, I want my day in court. And I'm okay with that. I love going to court, but I'm the only one who enjoys when we go to court, right? Like, the clients aren't happier when they go to court.
Right.
They're wasting time, they're wasting money. No one except me has fun with that.
Right. No, I understand. And also, would you agree too? I mean, at least this is what I've heard from many good trial lawyers, is that because they're a good trial lawyer, they go into court less because the other side knows that it's dangerous to go to court.
Absolutely.
I'll settle.
Yeah, the more you go to court, I think early on, the more likely you are to settle cases later on. But I think there also has to be, a crazy factor to it as well. And I think Nick Rowley does a good job of this, of encouraging people to, he said most attorneys build a bad habit of trying their bad cases because they can't settle them. He said that doesn't get you in the right space. He said you need to try your good cases. Pick a case and say, I know this is a good case. What's my demand? My demand is a jury trial. That's it. That's the only thing I'm offering you. That's my settlement offer. Take it or leave it. And I think that needs to come into play because, I have cases that I know are lower value, but I'll fight them anyway. And I'll waste my time on them because I know that my clients are entitled to this, and because opposing counsel needs to know that I'm not going to settle just because it's a low value case, that I'm not going to give up on a client. And so there's that balance there, right? Yeah, you got to settle those, but you also don't want to just settle your bad cases. You got to try your good cases too.
Right. Got it. Okay. Excellent. Good stuff. Well, listen, I appreciate this. A lot of good wisdom here. And so final thoughts that you want to share with the audience about your firm and best way to connect.
Best way to connect is you can find me, you email me, Jordan, Jordan at palacelaw.com, or find me on any social media. I'm at Jordan L. Couch. Final thoughts, man, if you're getting into this practice or getting into law generally, remember that one, it should be fun. If you're not having fun, it's because you're in the wrong area of law or the wrong firm. Try to find something new. And be a leaf on the wind. You heard my story. I did not plan to get into workers' compensation. I stumbled my way in here by just being open to opportunities, and I love it. And I'm stuck here for life because I'm having so much fun with it. So I think really just kind of opening yourself up to possibilities is a good way to approach this profession. And same with cases, right? Open yourself up to cases you might think are a long shot. And sometimes those are going to be your best memories and most interesting things you find yourself talking about on a podcast 4 years later.
Excellent. Good stuff. And your practice is just, you said state of Washington and Oregon now.
Yes. Now
Okay.
It's just recently Oregon. Yeah.
Okay, good. So people know that if they want to connect with you.
Yeah.
Okay, good.
Absolutely.
Well, listen, I appreciate it. For everybody, again, Jordan Couch with Palace Law. And this is sponsored by EmotionTrac, which is a legal tech platform that helps litigators prepare for mediation and trials with our Insights platform. Thank you, Jordan. It was really fun. Appreciate the insights.
Yeah, thanks for having me.
You bet.